Hello everyone. The next question I am gonna answer is from a data privacy learner. He says, I am learning data privacy and I am confused about PIA and DPIA. I want to know the differences between and applicability of PIA and DPIA. Okay. So the main difference is basically this depends on which regulation you are following, which regulation you are referring to. Right? So DPIA is specific to GDPR, while the PIA is a more generic term which is referred in many other regulations. PIA is basically identifying or evaluating how this personal data is being handled in the organization and how it can impact the individual or the data subject. That's a PIA. In that assessment, if you identify that there is a high risk activity, fine. So the GDPR in that case specifically says that for the high risk activities you have to do the DPIA. So in GDPR, the DPIA is a formal requirement to be conducted for high risk activities. And what those high risk activities can be: when you are performing the processing of sensitive data at a large scale, or user behavior at a large scale, just for the example. Right? So there may be more similar use cases, but you have to identify what are the high risk activities which can impact the rights and freedom of the individuals. Right? So while the PIA is defined as a just evaluation of identifying how this data processing activity can impact the individual. So many people also says that you do the PIA first, then you identify the high risk activities. For that you have to do the DPIA, and that is absolutely your choice, because this is not defined in the regulation as such. Fine. So the regulation in the GDPR specifically defines only DPIA, while the other regulations are, some of the regulations are making it mandatory to conduct PIA, and some of them is just make it as a recommendation. Fine. So in some regulation it is required, in some regulations it is just a recommended activity that you conduct the PIA so that you can address those concerns. So the requirement here is identifying how this data processing activity can impact the individual, and if you identify there can be an impact, then you address that particular gap, right, or particular risk basically. Right? And if you are following the GDPR, or you need to comply with GDPR, in that case, if you identify during the PIA, if you identify there is a high risk activity, then you have to formalize this assessment and maintain it as a documented information by conducting a formal DPIA. Right? So that's the primary difference basically. Otherwise, if you talk about in general, many people are confused and there are some overlapping also. Fine, because some people conduct the PIA but they name it as a DPIA. Some people conduct the DPIA but name it as a PIA only. Fine. So it totally depends on which regulation you are following. These are just two different terminologies, and generally the PIA is not specific to high risk activities, while the DPIA is specific to high risk activities coming as a requirement from the GDPR. I hope I'm able to articulate the differences, what the differences are. And if you have any more questions, please feel free to ask me a question. Thank you so much for watching.